Mr. Speaker, I rise in support of this bill. It is an important step towards making our workplaces fair for every worker. The process of seeking redress must not only be fair, but also feel safe, especially for those going through difficult life circumstances or personal challenges. Every worker deserves to feel that if something goes wrong, the system will hear them, not haunt them. And for union members, we will go further. We will assist them. As part of the NTUC family, I see daily how fairness at work changes lives, from job seekers rebuilding confidence after rejection to workers finding understanding employers who give them a second chance. For these workers, fairness is not an abstract principle. It is deeply personal. It restores dignity, trust, and hope. Mr. Speaker, while awareness of workplace fairness has grown, many workers still fear speaking up. MOM's Fair Employment Practices report in 2023 found that only about 30% of employees who experienced discrimination sought help, a decrease from 35% of the year before. Most who stayed silent cited fear of being marginalized or harming their careers. And that is why this bill is important. It assures both workers and job seekers that redress can be sought safely and confidentially, and of course fairly. They must know that they will be heard without fear of retaliation, and their dignity will be protected. Take, for example, a worker who feels sidelined after returning from maternity leave, uncertain if raising her concerns will affect her standing at work. Under this bill, she can first raise the matter through her company's grievance process. If unresolved, she can turn to mediation at the Tripartite Alliance for Dispute Management, or TADM, and if necessary, to the Employment Claims Tribunal, or ECT. If she is a union member in a unionized company, her union can support her at every step of the journey, even to represent her at the ECT. Each step is designed to be fair, affordable, and private, helping both sides find resolution without hostility or fear. Workers are protected from retaliation throughout. This protection is for all workers, regardless of ability or disability, including those managing mental health conditions. For them, assurances on confidentiality and empathy are especially important. And for those who are union members, our unions stand ready to walk with them through mediation, to represent them if needed, and to ensure their voices are heard with dignity. Now consider a job seeker who discovers that a potential employer withdrew an interview after learning her age or disability. Under this bill, she too can bring her case to TADM, and if unresolved, to the ECT for resolution. If she's a union member, NTUC will be on hand to support her during her negotiations with the company, the mediation process, and even at the ECT. Now, this ensures that fairness begins not only in the workplace, but from the very start of one's employment journey. These examples remind us that fairness is not just a concept. It is a process that protects dignity and trust, whether a person is seeking work or already working. Even with good laws, fairness is ultimately delivered by people. Frontline officers, mediators, and tribunal staff must be trained to handle cases with care and empathy. Our union leaders and industrial relation officers have deep experience in handling workplace disputes, and will also go further, training to be equipped to handle workplace fairness cases, so that they can recognize distress, manage sensitive conversations, and uphold confidentiality in every interaction. A fair system must not only be efficient, but also humane. So this bill rightly provides private proceedings for workplace fairness claims, whether before the ECT or the High Court. This protects confidentiality, reduces reputational harm, and ensures sensitive disputes can be resolved respectfully away from the public glare. The judge-led ECT model, without the need for lawyers, levels the playing field for workers, including those who are PMEs, and the expanded claim limit of up to 250,000 means more PMEs can seek accessible and affordable justice. For serious breaches, especially those that undermine our shared values of race and religion, I note that MOM can also pursue state enforcement action against employers where public intent requires it. Now, this balanced approach protects individual dignity while maintaining public confidence in the system. Workers and the public alike must have confidence that serious misconduct will not be hidden behind closed doors. How will MOM calibrate when to exercise discretion to name and sanction employers while still preserving fairness and confidentiality for individuals involved? So even with a proper process in place, workers and employers need more guidance to navigate claims. I have 3 clarifications to ask from the Minister. First, a common query I've heard is how the claims amount will be determined. Will the Ministry be providing guidelines so that workers and employers will know what to expect when faced with a claim? Second, while it is important for ECT proceedings to remain private, published judgments are useful to provide guidance to workers and employers alike on what to expect for claims. Will the Ministry consider publishing ECT judgments on an anonymized basis? Third, even with judges playing an active role in ECT proceedings, it can be very daunting and challenging for workers, especially those who are less educated, to understand what is going on. While NTUC and our unions will play our part for all our members, what more can be done to assist and guide claimants who need more help? Mr. Speaker, fairness at work should not begin at the tribunal. It should begin in the way we treat each other every day. The best dispute resolution system is one that workers rarely need to use because trust and understanding are built early. Our unions work hard to ensure employers have fair workplace practices and grievance handling processes in place, as this builds confidence amongst managers to administer employment, promotion, and training decisions meritoriously, and transparency and mutual trust in how grievances are to be handled respectfully. When employers take steps to handle grievances promptly and respectfully, conflicts can be settled before they even escalate. This is especially important for smaller companies, where a timely conversation, a listening ear, or a fair explanation can prevent tension from mounting and turning into a claim. I'm encouraged that MOM and TAFEP will continue to guide employers in setting a fair, simple, and confidential grievance channels, especially for SMEs with limited HR capabilities. When these systems are clear and trusted, workers feel safe to raise issues early, and managers gain confidence in addressing them calmly. Employers and employees should also be encouraged to discuss adjustments or concerns constructively, especially when workers have unique or face new challenges. Now, such understanding does not promote inclusion. It prevents misunderstanding and mistrust. Because when workplaces are empathetic, transparent, and fair, issues are resolved through conversation and not through confrontation. This is how we move from compliance to culture, from managing disputes to preventing them. Mr. Speaker, tripartism remains the cornerstone of our workplace harmony. Our unions, working alongside MOM and employers, help to make fairness felt, not feared, guiding workers and companies through challenges with calm, respect, and trust. This bill reflects that partnership in action. Workers assured of fair redress, employers confident of clear processes, and a society strengthened by mutual respect. It is truly a bill that is pro-worker, pro-employer, and pro-Singapore. Mr. Speaker, in Malay, please. Tuan Speaker, kita sering berbicara tentang keadilan di tempat kerja. Tetapi keadilan bukan sekadar tentang undang-undang. Ia tentang maruah, kemanusiaan dan rasa hormat antara satu sama lain. Undang-undang ini memastikan bahawa setiap pekerja tanpa mengira bangsa, agama, umur, jantina atau yang mempunyai ketidakupayaan atau cabaran kesihatan mental dilayan dengan adil dan penuh dengan belas kasihan. Kita tahu bahawa apabila berlaku diskriminasi, yang terjejas bukan sahaja satu individu, tetapi seluruh masyarakat yang terasa kesannya. Bagi pekerja yang kurang yakin untuk mengemukakan aduan atau tidak tahu cara memulakan proses, saya menggalakkan mereka untuk menjadi ahli NTUC sekerja. NTUC akan membimbing dan menemani mereka sepanjang perjalanan mendapatkan keadilan supaya tiada pekerja berasa keseorangan dalam menghadapi cabaran di tempat kerja. Tuan, rasa terpinggir atau tidak dihargai boleh membawa perpecahan dan kehilangan kepercayaan. Sebab itu, semangat undang-undang ini penting, bukan hanya untuk melindungi hak pekerja tetapi untuk memperkukuh perpaduan dan harmoni dalam masyarakat kita yang berbilang kaum dan agama. Apabila kita berlaku adil, kita sebenarnya sedang memelihara nilai teras Singapura, kepercayaan, kesepaduan dan harapan bersama. Keadilan di tempat kerja mencerminkan keadilan dalam masyarakat kita. Setiap tindakan yang berasaskan empati dan belas kasihan walau sekecil manapun menyumbang kepada keamanan dan keharmonian tanah air kita. Mr. Speaker, fairness at work strengthens the very fabric of our society. When every worker, regardless of race, religion or background, feels respected and valued, we build not just stronger workplaces, but a stronger, more united Singapore. This is a landmark bill, fair, forward-looking, and rooted in trust. It shows how tripartism turns values into action and how fairness, when practiced with empathy, becomes a shared strength. Fairness is not only written in law, but lived out in every workplace and every act of respect between us. Mr. Speaker, I support the bill.